It's not a radical system, but it has been a successful one. Despite some controversies in early implementation, it has worked in enormously cracking down on sexual assault in Japan because the counterfactual was that a bunch of judges were old Japanese men who did not take these cases very seriously, did not put a bunch of effort into them, and were not liable to what was going on. When this procedure was implemented, it meant more women were on these panels, more women were advocates for what was going on, and more women were able to sit down with people in these discussions and tell their stories in such a way that they got decisions that were just. 3 broad bits of setup and then 2 arguments. Firstly, I'm going to explain why principally this is more fair, and secondly, I'm going to explain why this leads to better outcomes. In terms of setup, first thing I'm going to explain is what is unique about civil jurisdictions, which is that these are systems that use much more of the inquisitorial legal system. So it's normalized for a judge to be enormously involved in the court proceeding. They ask questions, they function more similarly to a prosecutor than anything else. But secondly, in the vast majority of cases, they don't use juries. Juries aren't involved with their legal proceedings. At all. Second, in terms of setup, is where is this generally used? It's the vast majority of Asia, lots of Europe, basically every country that wasn't colonized by England throughout history. It's the status quo, for example, in Japan, France, and Germany. Lastly, in terms of our model, 4 broad things. Firstly, in terms of these individuals, obviously we pay them and select them in much the same way that we do, give them provisions in much the same way that we do with juries. We just make it a random lottery. Of course, we wouldn't allow people to strike them because obviously this is a system that is inquisitorial rather than adversarial, so that obviously would play far less of a factor. Secondly, in terms of which cases we would use them on, we would use them in sort of cases that involve more severe forms of criminal punishment. So obviously this will deal with any claims they might make about huge degree of backlog. We're not going to use these for the vast majority of like minor claims like littering or like the car speeding tickets. Claims that are far more severe, and in particular claims that are far more moral. So claims around broader questions of sexual assault, claims around fraud, etc. Thirdly, like juries, we'll have specific cases where we will just sort of impair them. So for example, technical or complex legal questions about like bits of minutiae. Obviously, we probably won't use them in that instance. We trust policymakers to decide where and when they will be useful. In terms of the specific instances in which I think these cases will come up the most, I think it will be far and away moral questions. For example, when someone has acted dishonestly, cases of sexual assault, cases around defamation, where the public's incentive and interest and perception is at the heart of what we're deciding, is the heart of what we're deciding in these instances. So, with that said, the first argument I'm going to make is just one of fairness. And the core claim here is that the most important distinctions in the cases where these people are used are not litigious ones, they are moral ones. How much, for example, poverty affects what you have done and whether or not you will be involved in recidivism. Your level of moral culpability in a crime that maybe you've been affected by a series of biases towards perpetrating. Your mental health that might have pushed you into this sort of series of claims. The core thesis of this is that you have a right to have a group of your peers decide what is not objective. In that, because almost all of these claims are predicated on subjective decision making, it is unfair to have a set of individuals or one individual make a claim of what is or is not moral. That should be in the way that we do with basically every other moral judgment, a consensus of society, a referendum on what is or is not okay. Second plank of this argument is one of accountability, which is not only is there an actual risk of corruption or bad decisions, but a perceived risk in that in the inquisitorial system in particular, when the judge acts as both prosecutor and executioner, it conglomerates power and monopolizes power within a specific individual. Which means you're far more likely to lead to a series of internalizations that you can't understand without people expressing their own thoughts and challenging their own thoughts and giving pushback on arguments. On our side, you just have more numbers in order to get this out, but you also have the actual accountability in order to dissent and to make claims to that degree. But thirdly, I think most importantly, the severity of punishment necessitates that individuals should have a set amount of control over what is going on. That is, that in the vast majority of cases or states that we're talking about, these are states that legalize things like the death penalty for individuals. And our claim is such that, given that this affects your life to an exorbitant degree, and given that the core principle of the justice system is that everyone who enters into it is presumed to be guilty, or presumed to be innocent rather than guilty. It is unfair for us to conglomerate the power that such a severity of punishment within one or two individuals. That at the very least this should be democratized more. We should allow more people to have input into it. And the fact that anyone perceives that they can have input into it is why you actually get far more buy-in on our side. It's why, for example, you're far more likely to have people push for legislative reform if something doesn't work, rather than just think it is an opaque system. Because members of the public are able to come out, are able to publicize their dissent, are able to get involved in this procedure and tell people what is actually like behind closed doors, rather than allowing those people to get away with assuming that it is okay. Second argument I'm going to make is one around representation. Before I make this claim, I want to preempt a claim around why these individuals are better than juries. Obviously, as we explained, in some contexts there may exist juries, so this is a substantive push in those specific contexts, but it also deletes any claims we might get in countermodeling as to why as to why juries are better. Three broad reasons. Firstly, the investigatorial approach is particularly good when you have lay people being involved in the process, for the reason that being able to ask questions, being able to get around any misinterpretations you might have of the law, or actually ask specific questions to witnesses is far more likely to make it more clear what juries want, and also to make it more easy for prosecutors to determine what juries want, and so to serve up the best evidence. But secondly, you're much more likely to get counsel in terms of from the judge or from the actual experienced judge than if you are on a jury where you do not have the ability to gain access to any of those things. But thirdly, I think it is far more likely that you have more people who are more interested in signing up to be sort of a member of a lay judge than you are to be a jury on their side. For the reason that it is far easier to convince people they can be on a panel alongside people who are experienced than it is to convince someone that they have to go into the deep end and do it all themselves, which is, I think, particularly important. But fourthly, juries in a lot of ways don't have to justify their decisions in such a way as you would if you were a judge, which is why I think regardless you get far more transparent series of justice, which makes it easier to investigate, easier to reform, and easier for people to make better decisions going forward into the future. But absent of that, I'm going to explain with the comparative of judges why it is better to have more people and more people who comprise members of the public. The first part of this argument is just one of demographics, which is that judges skew old, they skew particularly rich, and they also tend towards, especially in the countries we're talking about, Germany, Japan, France, and they skew very much towards being male. And this has a variety of implications that are particularly bad when you compare it to a census of the general public, which is far more likely to, for example, be composed of immigrants who make up a larger portion of the majority in countries like Germany and France. More and more are likely to be younger and are more likely to be, for example, women. On our side, we're able to co-opt the benefit of expertise that they claim around judges, because judges can still counsel people, can still give them advice, can still give them expertise. People are able to stand on their own experiences and advocate for that. We have more minorities involved, we have more women. I think that seems pretty good. Secondly, in terms of why judges can be bad actors, the second claim here is just that the fact that they've seen a bunch of cases often biases them in bad ways. That is, that often in a lot of cases when you're forced to watch a bunch of cases of people who are poor commit crimes, it creates biases within your mind that those people are likely to do that alter your ability to be objective about it. But secondly, there is a series of confirmation biases about past decisions that you have made, which is that if you let someone go early and they go on to kill someone, things like the trauma coming from that decision are likely to bias you against that. The comparative is just that someone who has never been on this panel obviously doesn't have those series of traumas. On our side, I think lastly, we're able to get around things like judicial capture because you're unlikely to be able to buy out everyone in society, but it's far easier to just buy out one or two specific judges. So you're able to get around that harm there. Proud to affirm. Thank you, Chris.
4 things in setup, then 2 arguments. First, what is civil law? Notably distinct from common law. Common law, such as England and Australia, you have a host of precedent. In civil law, you have very large volumes of law. It looks like heaps of legislation codified into legal codes. It looks like they're extensive as fuck. There's not much room for judicial interpretation. It looks like a bunch of law reform commissions doing huge amounts of research, making a bunch of recommendations to governments who then pass them. Second thing to note about these systems is they're often inquisitorial, but NEC has to support AF has to support making all of them inquisitorial. It looks like the judge investigates. We can get around this because the difference on their side is that they necessarily have to have lay people doing the inquisitorial parts of the justice system. We don't. Third thing, and penultimate thing in setup, is that they say, well, we can model in that we only do this in a small amount of cases. That's not their burden. This might be the place where the debate is best for them. They have to support this being a system-wide change. They have to support this being the case for the whole justice system. Fourth and final thing is that we're able to do a bunch of counter modeling with all the extra money that they use on this. We're going to spend some of that on things like DEI programs. This looks like increasing the judge quotas, increasing scholarships at law schools. Also looks like allocating judges specifically. Looks like an increase of women on essay cases. Cool. 2 arguments in the rest of this speech. First, on how this wastes resources and time. Second, how lay judges in power lead to the abuse of power and worse outcomes. Couple of met to the first. So what this argument prove is essentially that this wastes resources and time. That's the bad thing, because the justice system functions best when it does not waste resources and time. First, they just require more people. This is pretty intuitive. Instead of having 1 judge per case, they have 9 judges per case. Even getting rid of all the lay judges, they have to have 3 experienced judges. We have questions about their model. They have to explain either it's one of 2 scenarios. Either first, you have the same 3 judges which rotate around to different places, in which case you might get biased if you have one panel over another panel of judges. Or second of all, it's these 3 individual, it's a bunch of individual judges who all rotate around separately, in which case you have to wait for all their schedules to line up. They obviously have to cost the time cost of that. And additionally, the fact that they have to have at least 3 judges, this means they are at least 3 times as slow at doing justice and 3 times as expensive as doing justice, because they have to expend a bunch of time and resources on hiring more judges, and that seems pretty bad. It means that you're less able to do a bunch of cases in a small amount of time. The impact of this costs a bunch more time, also costs a bunch more money, and this is especially pernicious because it means judges already get paid very high wages. But in cases like, especially developing countries, where you have to get judges in overseas, you have to pay rates which are comparably a lot higher. It means you have to the cost for justice is so much higher. Second mech is you have to train these lay judges to think the way that ordinary judges do. It looks like you have to train them on how to manage the inquisitorial system. Op is a very smart set of people. They don't explain how this happens. I don't think they can explain how this happens. What this should lead you to believe is that a set of average people, who are obviously far worse than Op, would struggle to understand how this would actually work, would struggle to actually be educated in this way correctly. We know this will obviously never be perfect. Even if it is, it will take an extraordinary amount of time. It costs a lot more. Instead, you have to pay these people. Also costs because you have to you have to pay people to do the training, but it also costs in terms of time, because it takes a lot of time to train people up. Third is it just means that instead of having 1 judge with 1 opinion, you have 9 judges with the 9 opinions. That means it takes 9 times as long because you have to do 9 times the amount of deliberation. Imagine, a panel with 9 people takes a hell of a lot longer to come to a decision than a panel of 1 person. I think it seems pretty silly because you have to have a whole bunch of time. It means you're less able to hear cases as much. Fourth is that appeals are far more likely under their side for 2 reasons. First, you're far more likely to challenge the process, as we'll explain to you in our second piece of substantive. But second, because you spend so much time arguing, with, your fellow panelists, your fellow judges, you're less able to spend a large amount of time writing your decisions. That means the decisions that you write are far less likely to be very stringent decisions. It means they're far more likely to have a bunch of holes in those decisions. Means that you're able to do a bunch more appeals. The extension of this is that a lot of states don't have money for the justice system because it's seen as elite, they don't like spending money on it, and also some states are poor, they don't want to have to take foreign aid because of the harms of it seems like foreign governments interfering. Also, they have to fund a bunch of common law reform commissions. Looks like this means that law systems cost a bunch of money. Note, even if these reasons are symmetric, it essentially just magnifies the cost of opposition because it means it just costs a whole bunch more. And it's pretty bad. Impacts of this point are fourfold. First, it detracts resources away from writing laws and civil codes. Civil law is constantly adopting, and therefore decisions are worse because you have worse codes to their side. You have less money to to put toward these. Second, you have slower justice, and that's pretty bad because there's reputational damage in waiting. There are a bunch of mental health effects to waiting such a long time in order to get a decision. There are a bunch of costs in the short term for people who have to stay in courts for longer. It also means that if you are being tried for a crime and you're innocent, you're being held in jail until you can get out, unless you have to pay for that, and that costs money. Thirdly, I guess, is it detracts funding from other things. Either they have to lower judge wages, in which case they get lower quality decisions, or it takes money away from things like investigative tools. They're less able to do better investigations. Fourth impact is that you have less time for appeals. They're more likely to appeal for the reasons I explained to you before. That means you have less time to hear these appeals, you get worse justice in total, in summation on their side. That seems pretty bad. Let's move on to the second, at the end of this, you lose resources, you lose time, that's really bad for the legal system. Second argument then, on why lay judges in position of power leads to a bunch of abuses of power, that's pretty bad. First, it's just to say judges are really good because they're well educated. They have spent a lot of time, being educated in law. They haven't necessarily explained why, you have some biases. They never explain to you why that necessarily means you're going to make bad decisions. We just explain that people who have studied law for decades of their lives are going to be more apt at making legal decisions than people who you just pick randomly off the street. Second, they're well seasoned. They've spent lots of time deciding a bunch of legal cases. That probably means they've learned from the mistakes of the past in a way that lay people haven't. Second thing to say is that there are judges are lay judges are more involved in investigations on their side, and that leads to a bunch of abuses of power on their side. That looks like the reason that this is true. First thing to explain here is how arrest warrants are done in the first place. In order to get a warrant, you have to do it by applying to a judge. And when that judge is yourself and you're also doing the investigation, you're far more likely to willy-nilly award these warrants. Looks like that you have a bunch of incentives to try and keep these trials. You want to try and keep these trials short, even though you're not necessarily able to. It means you're far more likely to give these warrants perniciously because you want these things to be done shortly. To be done in a short amount of time. That looks like you're more likely to give arrest warrants, search warrants, etc. The impacts of this are threefold. First, it means that you have incursions of privacy in ways that ordinary professional judges wouldn't be willing to do because they don't have necessarily the time incentives. That looks like the state incurs on a bunch of your privacy in ways that's really pernicious, ways which take away your dignity as a person. That seems pretty bad. Second is that it means that it detracts people from actually taking cases to court because you have to make the decision of either you go to court and you have your privacy infringed, and that seems pretty bad, or you just have it disbanded. I think people are far more likely to opt for the second one. Third and finally is that there are a bunch of psychological harms of having your privacy infringed, especially in very specific cases which they like to talk about. Cases like sexual assault. Imagine the psychological harms of having your counselor subpoenaed because some layperson, your counselor subpoenaed because some layperson was like, oh, they might have the good information. They're the person who's going to solve a trial. I'm going to give them a subpoena warrant. In which case, a judge on our side obviously wouldn't have done that. That brings up some pretty shit emotions. For those reasons, vote nay.
Tom wants efficiency. Tom says it's good to have one judge, one opinion, things happen quicker, you don't need to discuss, decisions get made. I hope that this team breaks at Australs. I would be very excited for them if true. And if they do, I'm going to give them a one-person panel. And it's going to be the most efficient deliberation of all time. Because that's the world they'd like to live in. And I'm sure it would be very, very fast. But I think at the point at which you're doing an Australs final, something that's really important, much like a murder trial or a sexual assault trial, you'd probably feel pretty good to have multiple perspectives competing against one another, even if that meant that your deliberation went from being 20 minutes to being 45 minutes. Because maybe these trials go on for a while. We would note what I'm going to explain, which is there are a set of constraints that ensure that they don't do that, and that has already been uncovered in the status quo. But it doesn't really matter, because the length and the impact that these cases have on people's lives obviously outweighs an argument of efficiency. It's unclear to me the way in which this negative team is trying to win this debate. I'm not sure that they understand how the system operates in the status quo. Given that, I'm going to explain it further in this speech. The first thing I'm going to deal with is the crux of their case, which is essentially a contestation on the implementation of this system, and I guess delivering a list of of generic problems that exist within it. Let's deal with them all individually. The first thing that the negative team says is that it's going to be inefficient. There are a list of reasons why this is untrue in the status quo. Firstly, there are maximum case length implementation. In Japan, I think it is 6 weeks. It could be even shorter than that. But importantly, even if you don't believe that is true, which it empirically is, they also have minimum amounts of evidence that need to have already been uncovered before these cases start. And that means that trials have already come a certain place before you bring in lay juries, and that is the reason why they necessarily occur quicker. So they are two pieces of empirical evidence as to why the inefficiency claim isn't important. But I would also just draw to my introduction, where in panel, I would rather you weigh the impact of a murder trial with the potential of somebody going to the death penalty is on the impact of having one that lasts a little bit longer. That just does not seem like a debate-winning claim for this negative team. The next thing they say is that you can have things like DEI initiatives. Firstly, this team obviously needs to support the status quo, and that would obviously only happen in jurisdictions who already have DEI programs. But secondly, DEI is incredibly difficult for a number of generic reasons, like there are systemic barriers in the status quo that make it hard to do this. But also, DEI often only pertains to things like race and gender. However, there are class barriers that DEI often fails to attack, and that's the reason why when you bring in ordinary people and lower income people, that's how you get the best example of diversity that DEI initiatives can often never be able to actually enforce. But importantly, it also just doesn't account for a list of other mechanisms of diversity, things like professional diversity and the jobs that people work in and the life experiences that they have. You cannot model that in a DEI program. That is obviously not the panacea to the problem in the debate. The next claim from the negative team is that it's really difficult to train people to do this. The problem with this panel, it is either at best uncomparative to a jury system, but even when they're not proposing a jury, it's obviously just not as good as it obviously just means they take on all of the harms of having solo judges or 3 judges who are in a professional capacity in this case. But importantly, the lack of training is the benefit, because it means that you get everyday people relying on things like their intuitions that are often of empathy, making these decisions in the case. And that's particularly important in things like murder, because people have experiences of people like relatives in the prison system. That is the reason why they have incentive to lead with empathy when they're making these decisions. And importantly, that's something that doesn't exist with judges, because as we explain at Archie, these people in positions of privilege likely do not have that experience. But even if you believe that they do, and they come from a necessarily diverse background, that still doesn't matter, because there are a list of other reasons as to why these judges have biases that go unchecked, for all of the accountability mechanisms they give you, but also for the reasons that they just do get fatigued by the amount of cases they're dealing with, and they rely on the biases of the precedent of the cases that they've done before that. So that still doesn't even matter. But even if you believe, in our worst case, that these decisions come off too harshly, and lots of citizens want to give the death penalty, not only do I believe that it's incredibly unrealistic, but also I just think it's more likely to manifest in citizens taking cases seriously in instances where professional judges wouldn't. And that's when Archie explains in Japan the scale of sexual assault cases. This means people are able to operate as lay judges and actually give them the time of day that they deserve, when a world you just never get in their system, which is the status quo. The final claim they make is that this operates really poorly in developing countries. I am somewhat confused by this, because it's obviously speculative, but importantly relies on an assertion that this is a massive, massive amount of money. That's just not true. Like, these cases don't last long enough for it to cost people that much money. But regardless, I guess it's money well spent regardless. But importantly, here, judicial capture is just far more common in developing countries anyway. So we have to be comparative about that harm. Our characterization explained by Archie, importantly, unresponded to is more important here. That's on feasibility, that's their case gone. Secondly, on fairness, this is debate winning, we've already won it, they haven't responded to it, I'm excited for it to end. We explained to you that given the large impact of the trials that go to these courts, that you need to have things like accountability, but through multiple perspectives, and you need to have things like representation through diversity. I'm going to explain 3 things in our case now. Firstly, an explanation as to why this is principally important, which has not received a response from this negative team. We explained to you at Archie that citizens have a right to be represented by their peers in this way, and importantly, individuals who operate within the legal system and operate within countries ought to have the right to be able to determine the outcomes of their peers in society. This is because they have shared experience with one another. This is because they participate in other elements of the legal code and therefore are deserving of representation in this way. And importantly, because of the impact of this is why we need people to be able to operate in this way functionally within the system. It also just means that people are better participants, which achieves our outcome and our impact of of accountability. Because now individuals are locked into the legal system in a way that means they actually are paying attention to the outcomes of cases and the decisions of judges and the acquisition of evidence in this way. The second thing we explain on accountability, which is that judges see a lot of cases and there is bias evidence in the precedent that they set, and that is necessarily unaccountable in a world in which you don't have lay judges operating as a comparative to the sorts of evidence they're doing. This means that where judges are using things like illegal evidence, there is a panel of 9 through which you can compare that against. It also just means you get far better discussion between the judges on the sorts of evidence brought up. Tom says, well, now you might infringe on people's privacy. Obviously, individuals don't have an incentive to do this for all the reasons we give you as to why they lead with things like empathy, but importantly, in the principled obligation they have to participate. Therefore, they don't have an incentive to do privacy interventions. But also, that would obviously exist in the status quo anyway, like the provision of evidence improperly would exist within judges. At least now you have an accountability mechanism of lay judges to be able to work against that. But the example they give is someone in an essay case getting their therapist subpoenaed. I would say probably what is more traumatic in an essay case is having experienced essay. That is a tipping point that I don't think is necessarily debate-winning for that individual who still has suffered trauma. But importantly, if their therapist contains evidence, probably worth bringing them into the trial regardless, right? Like, this is where on their side you get judges that overlook important people in a trial. That person maybe has testimonies of the essay occurring. That's the benefit you get under our side because you have more people providing evidence. This way you can compare things don't get lost in the mud. Maybe it takes longer. We've already stated we're going to co-opt that benefit, that's fine, whatever. Finally, on discussion, this occurs when you have the diversity of people within the panels. The discussion means you allow people with all of the legal expertise that they state to you. We just provide more expertise to be able to talk against one another. That is the benefit you get on our side of the house. That is how we co-opt all of the best arguments of their case and flip them on our side. Finally, on outcome, they say that judges are the GOAT because they study. We've given you a list of reasons as to why they are bad, but importantly, even if you don't believe all of the things in the status quo, they are uncontested. At least now you have a force of actors that work against their perspective to be able to deliver better verdicts. This is the reason why the system improves. This is how people's cases get taken seriously. So proud to affirm.
Thank you. Second.
First on time, cost and resources, then on the quality and negative externalities of the investigation. But before that, I want to note something that is in our setup, doesn't get responded to by this team, but kills a lot of their arguments, is that civil law has lots of codes within the law, which means there's not a large room for interpretation. That means everything that they talk to you about male judges interpret this thing vastly differently than female judges would interpret this thing or women would interpret this thing, does not stand that much in the debate. It gets mitigated massively because you have to follow sentencing guidelines that are in the rules. The ways that you gather evidence you have to follow within the civil code. Which means this part of the debate is vastly mitigated. What is not mitigated at the end of that though is the time and resource claims that we make. Those still stand. It's not, maybe each court case only takes 6 weeks, but it's still 3 judges as opposed to 1 judge. So it is 3 times as long on their side. Doesn't matter how short they make the case, they're still going to take far longer. First, I'm going to deal with time because I think that's how we get up ahead a lot in the debate. Gave you a few responses. Firstly, they say there's a maximum case length. I know that this response, as we explained before, does not defeat the argument that it just takes 3 times as long at minimum to be able to do this. But we also didn't even get a response to the questions that Tom asked about whether we're getting judges to align together or we're moving them around together on each thing. Again, still needs to be responded to by the team to explain how their system works. But all this mitigation does is hit their deliberation benefit. Because they're like, oh, there are people that need to talk about these things. You need to hear every opinion in all 9 people. But then they cut off the case length at a certain time. There's no way that you're possibly going to hear everyone's opinion on that. All this does is mitigate their own argument without affecting ours. The next thing they say is taking longer is fine. This does not refute the impacting that Tom gives you, because taking longer blocks out other cases being able to give you. Maybe at Australs they do want 9 people on their panel at each time, but I would suggest that means you can't run all the debates together at the same time. The tournament will go for 3 times the length. USyd can go, but no other institution will beat Australs. The end is coming. Like, maybe this team could afford it, but the average person cannot. I suggest that is problematic of blocking out people who don't have the state funding to stay there as long. This means that our time claim is still able to stand in the debate. We give you a series of impacts at Tom, explain how it actually impacts the argument with the quality of cases. You're less likely to be able to do things like appeals. There are less resources to be able to do things like judge training to make sure they're fine, make sure they do programs that mean that they're not racist. All those things that we explain are not able to be done on their side. I think that because of that, the time claim gets us ahead a lot in the debate. I'm now going to be generous and spend the rest 6 minutes of this on the only things that they talk about, which is on the stuff on quality and negative externalities. First, I'm going to flip this on the stuff of abuse of power, because I'm going to explain how the people who are likely to want to be jurors in this case, or whatever the type of judges they call them, are more likely to be of the privileged set of people rather than the disprivileged set of people they explain to you. The reasons for it, firstly, is one given by Archie when he explains that we can't strike anyone down, which means if someone goes, I hate black people when they're talking, hopefully that's not the clip, but when they talk about, when they're talking about in the court case, you cannot strike down that person, and that person must stay in the case. This team is unable to remove them from being a juror on this case. Obviously, if a judge does that, we have mechanisms to get rid of that judge for being outwardly racist. This team has to just stand there and cop it and let this person investigate a bunch of things. But I say the second reason that it's structurally likely is that it's a big time sink. There's a large cost, there's lots of effort. It is different to being a juror, as they explain. You have to go as a man and interview women about the sexual assault they've had and ask them about it during that investigation process. If you're a woman who's gone through that, you have to relive someone else's trauma. Not only listen to them talk about it, but ask them questions about it that just would be really cathartic for you and hard to go through. If you're someone who has a similar problem in your life and feels relatable, imagine how awful it would be to watch other people going through and asking them about those questions. That means they're unlikely to want to be on these cases and are likely to find some way to strike themselves off. What that proves is that you're likely to get the more aggressive sets of people doing it than the ones they explain. What are the impacts of this? Firstly, I think it means that these people, even if it's just the crazy people and that's the only party we believe, do the investigation and questioning on their side, which I think is incredibly harmful. Because what that looks like is aggressive men who hate women questioning women about their trauma and about their sexual assault. And I would say that's a far more certain impact than the wish-wash of what the answer of the case is going to be. When this team doesn't actually prove that they get on not just the balance of probabilities, but beyond reasonable doubt that they're able to send this man to prison. I think that is super speculative from them, but this is a certain harm you can weigh, making them relive their trauma. Note that they can't mitigate this by saying, oh, we wouldn't let the crazy man do this, we'd rather require all 6 of them to do it at the same time, because that mitigates their benefit too. It means a person of color in a panel where there's the majority of white people, because they're a majority in a nation, is also unable to go out on a limb and ask questions, because the white people say, no, you can't ask about that. So either each person's able to do that, and they have to copy the crazy people and do it, or they can't get the diversity benefit because those people aren't allowed to go out on a limb either. Next thing they say is they get a more diverse panel. 3 responses to this. Firstly, I'm going to dispute the fact that they say, dispute the part where they say judges want to protect other old criminals, specifically want to protect men or rich people. 3 responses. Firstly, judges tend to come from places like liberal elite colleges, which are just incredibly progressive, because those are the most prestigious ones that mean you're likely to get on judge boards. It means you're more likely to be progressive than the average person. Secondly, I would suggest to you that judges who go into it get less money as a judge than they do get as being a lawyer, which means they are likely to do things like anti-crime. And I would say that things like sexual assault are a pretty egregious crime that the average person's against. This team may prove that they are like men and that they're not super against it, but I think they're still quite against it like the average person would be. But thirdly, I think the meta has shifted, and that if you are found to be against doing things like not finding people culpable for sexual assault when they clearly did it, I think you're likely to get in trouble, and they're at least scared of backlash, even if it's only an individual incentive rather than incentive for the average person. That flips that. But secondly, I would say that this just if you get the people to agree on their side, it just legitimizes the decisions of those old white and racist judges. Because they can say, look, I consulted the people who were people of color, I talked to them, I listened to their viewpoint. This legitimizes it, because you're likely to be able as a judge to trick the sets of people that they talk about as being independent thinkers. You can make them think, oh no, this is how the law works, it's complex, let me explain it to you. And then you explain it in a way that means your side is more likely to get the case through. But what this does is uniquely legitimize the decision. That means you get less law reform on their side, because people see it as a legitimate decision that people of color thought was fine, that women thought was fine, because there were women on the panel who said that it was an okay decision. That's far less likely to happen on our side, which means you get more political pressure to change the civil code. Note that's important for the thing I explained at the start. There's a low room for interpretation, so you just spend more time changing the codes, because that's where most of the decisions come from, as opposed to just changing the part on the decision. But thirdly, I'd say that if they were this evil, they would just rewrite the code on their side so that you have to follow the things that they say. They say you can't ask the therapist if they think asking a therapist is bad. Everything they say, the judges can just rewrite the code on, and that is a way that they can get around the things they say, because that deletes lots of their stuff on. People should democratically consent to it, because they can just change the stringent codes on their side and delete lots of that. The next thing they say is it's all on subjective decision making on most of the cases they talk about. Firstly, I think this misunderstands the civil system, where most of it's not subjective decisions, but rather confined objective decisions of low interpretation. But secondly, I'd say that the things that they talk about as being the most impactful and they try to win the debate on are just necessarily hard to prove. This team doesn't get any closer to proving it. Because maybe it is true that that a woman thinks, yeah, I think he did it, and the male judge thinks, no, I don't think he did. But neither of them had the capacity to prove beyond reasonable doubt that it is. They just think on the balance of probabilities the man did it. Given the debate is about guilty, it's about beyond reasonable doubt. This team isn't able to prove it. But I think what that suggests, this team is talking about the questioning and investigation part. First, I'd say in mitigation to this, that when you're investigating sexual assault, you probably get advice from a woman if you're a man on how to navigate that. At least that goes somewhat to mitigating their claim if it doesn't get the whole thing. But secondly, suggesting that the meta shifted, judges are scared of not investigating men entirely properly because it makes it look like they are protecting men who did sexual assault, and that's bad. But thirdly, I'd say that we flip this, because as I explained earlier, if you believe the judges at least want to get the men for sexual assault, they know what proof that they need to get to be able to get these men, which they're likely to be able to do a better job. And they can't say, well, the judges will advise on what proof you have to get, because then they can advise you, it deletes their benefit too, because then they can advise you against getting evidence that they think will be useful by saying, no, that wouldn't be useful, so you don't spend your time in a limited case time on that. On corruption, they say a few things. First, on corruption, I think first, there's a lack of interpretation, so it's hard. But secondly, we centralize it so it's easy to get it. You can just add one person, tell them to talk about jury nullification, and you can get a mistrial and delay it, so you never get sent to prison. They say you get a jury of your peers. I'd say you still have no control. You can vote and change the laws on our side. That's good enough. They don't control the laws on their side. These reasons negate.
All right.
I want to begin this speech with a clarification about exactly what these lay judges are doing, because a lot of their material, both about the costs of training up these lay judges and the ways in which they will make poor decisions, is contingent on the premise that much of what these lay judges will be doing is deciding complex questions of law that requires understanding. But that is not the case. Firstly, oftentimes this is mainly a debate about criminal trials, where complicated questions of law are less important. It's not that ambiguous what counts as murder or what counts as theft. The question most of the time is, did that person do it? Was there a murder weapon? Did they have the motive? On the balance of the evidence, is it more likely, or beyond balance probabilities, beyond reasonable doubt, did they do it? Secondly, in civil law systems, this is especially less the case because the law is more decided, so there are less ambiguous questions of precedent or exact interpretation of what the law is, which is why the lay judges are likely to be doing it less. But thirdly, we explain that these lay judges are used in selective cases where it is sensible to do so. So, for instance, if there was a criminal trial where the key question was one of law, for instance, whether a piece of evidence is admissible or not, that is probably a trial in which you would not impanel a group of lay judges and simply have judges decide that. Their response to some of these claims is to say, in civil law systems, there are less subjective assessments to make, like about fact or morality, because lots of the laws come from statute rather than precedent. But that idea doesn't prove that premise. The fact that law comes from statutes as opposed to precedent doesn't negate the idea that lots of criminal trials, you still have to decide whether or not the guy did it. You still have to decide whether or not he acted dishonestly when he was doing fraud, which is often a requirement of someone committing fraud. When you're sentencing someone, you still need to weigh up their moral culpability, how much they intended to do the act, how much we should take into account their background of impoverishment, how much we should take into account their drug addiction or mental health background. Those are the type of subjective assessments that the fact that more law is codified in statute doesn't nullify or remove. That's a clarification. Now I want to talk about cost. At the top of this, I want to give some weighing about cost, which is, as Mia explains, I think, quite eloquently, it is simply less important than the question of the principle or accountability or of decision making. Because we are perfectly happy to spend millions more dollars if it means that someone does not go to prison unjustly. 25% of all people who go to jail in Australia are raped in prison. We are perfectly happy to spend more money to make sure that we get that decision correct and that we are not punishing someone for the wrong thing. Equally, we're perfectly happy to spend more money if it means there are not murderers or dangerous criminals who should be in prison, who should be away from the community, walking around on the streets. It is unimportant. But I think the explanations for why this policy is more costly, I think, are silly. They firstly say you need more judges, but presumably not every trial under their side is a single judge trial. Like in the status quo in civil law countries, you might have a panel of 3 judges. If it's an appeal, you might have 5 judges. But secondly, if that was the case, it would probably be a bad thing. Like, it'd be a bad thing if you just had one judge only under their side, and you put all the power in the hands of that one person, for whom there is less accountability, especially when that person is doing part of the investigative process themselves, as is more likely to occur in civil law jurisdictions. They're more likely to overlook a piece of evidence or have their own biases play into it. So that would be a bad thing if that was what they were supporting under their side. Then they say, I'm very confused by this, you have to move the judges around or coordinate their schedules. Firstly, that's probably something that exists under their side if there are multiple judges. But I don't get it, it's not that hard. Courts do this all the time. You often, for instance, in a district court, if it's like a serious criminal trial, already have a panel of 3 judges. You can coordinate their schedules. Common law jurisdictions, many civil law jurisdictions do it as well. If we're talking about cases in rural areas, the judges often go on tours or circuits around together. It's not that hard to coordinate their schedules. The next explanation that they give for why it was so costly is you have to train the lay judges. Firstly, as I've already explained, there's probably not as much training is required as they say. But secondly, often lay judges probably defer to normal judges when the question is a complex one of law, right? You have 6 lay judges, they probably treat their responsibility pretty seriously, probably want to get the decision right. They have their own legal obligations as a result of being there, which means they're likely to discuss with the other judges, they have to justify their decisions. You don't need to train them in the law that much. The judges can explain it to them in the same way that judges would have to explain their decision making when you're doing a normal trial when they're delivering a judgment. It is not a massive added cost. And that's not a tension with our claim about lay judges being involved in other types of decision making, because we're making a specific claim about lay judges being involved in subjective, moral or factual decision making, and that is where it is beneficial. Thirdly, even if you did have to train someone, it is not that difficult. There are probably pro forma courses that you can create. In the same way that in common law jurisdictions, before juries go to deliberate, judges give them directions to explain what the law is that are, copy-pasted or get handed down from appellate court judges. It's probably not that difficult to train them. The final claim that they make under cost is that there are more appeals because you get worse judgments. Firstly, presumably you still just have the normal judges other than the lay judges writing the judgments. In which case, I don't see why they're that much worse. They can probably incorporate the opinions of the lay judges. You can probably have a transcript, if it need be, of the discussions that you had between the lay judges and the judges, or you can have the lay judges read over it and approve it. Secondly, appeals tend to be mainly about questions of law, like you have to apply for leave to appeal. Higher courts will do that when they have to decide an important legal precedent. Most of the time, you don't appeal questions of fact unless it's a really gross factual misfinding, in which case I'm not sure the marginal quality of the judgment makes a meaningful difference to the number of appeals. Their cost material is out of the debate. What isn't out of the debate? Firstly, we make a simple principled argument that is responded to extremely inadequately. You have a right to have your peers involved in the decision making, especially when the questions at hand are extremely subjective. Things like in sentencing, things like determining whether or not you did have the motive to kill someone, things like, for instance, whether or not you were dishonest when you committed a certain act. And this tape exposes people to the tyranny of, as they say, in many cases, one to judge in a way that is undemocratic and is discordant with the purpose of having criminal law to, as a society, decide who is not fit to be as part of our society, who needs to be sent to jail and sequestered away, and have a litany of their rights of freedom of movement and association and expression stripped away from them. And that is not a decision that should be made on one judge's apprehension or subjective decision of whether or not you did it, or your background, or things like that. And that is not a principle that they ever adequately responded to, and is enough to win us the debate. But even if that wasn't the case, decision making is clearly more important than cost. And we explain that much better decisions are made under our side when lay judges are involved in the process. I missed a page. Okay. Firstly, we explain that because you simply have more people in the room with a greater diversity of life experiences, and they can meet in the middle. And this is a discussion that occurs where both sides have to justify their perspectives and justify their opinions, which means, especially for something like how much we should take into account someone's substance addiction or mental health issues, it is good to have more people to force the judges to reconsider their biases and for the judges to do the same to the lay judges. But also, secondly, as a result of having more people, you're less likely to make mistakes. You're less likely to overlook a piece of evidence or not spot a pattern when you have more people in the room. But thirdly, the judges themselves have to justify their decisions more rigorously. Judges often deliver judgments that are too short, often don't consider every piece of evidence because there isn't someone looking over their shoulder to make sure that they're doing a good job. And that's something that is less likely to happen under our side. They say that there is a risk of abuse of power in investigations when lay people are involved. Firstly, this falls foul of a misunderstanding of quite how inquisitorial civil law jurisdictions are. Like, obviously, France still has police who conduct interviews with victims and witnesses and stuff. You still have prosecutors who are doing most of the evidence. Yes, obviously, judges are a bit more involved in the sense that they're not like in a common law jurisdiction where they can't present arguments or can't introduce evidence. But most of the time, it's still police and prosecutors. We're not getting some random guy to, interview the victim right after the crime happened. But secondly, the incentive for lay judges to abuse their power in this way isn't explained. They probably take their responsibilities seriously. They don't want to incur legal liability of themselves. They're probably briefed that if they do misconduct in the investigation, they'll be subject to some sort of punishment, and we could remove them for serious misconduct. Like if you said, I just hate black people and I want to convict him because he's black. But the better claim is what we make, which is that it's worse when you have the inquisitorial judges doing it alone with no one to cross-check, and they're the ones who are more likely to have an incentive to not consider all the evidence or to abuse their power because their career is at risk. They're the ones who are more likely to abuse evidence. That's the more meaningful form of accountability, and for all of those reasons, you should affirm the motion.
Let's knock out the principle. 4 responses. I want to mitigate this argument. Firstly, we are willing to forego representation when it is for utilitarian good. For example, we allow the RBA to appoint people on a technocratic basis. Or for example, during judicial appointments, in many places around the world, we don't elect judges because that's something we give to someone else. Secondly, people can still exercise their power or representation via other means, via the legislature. That's why we have the executive and the judiciary independent of the legislature, because people can enact their principle of representation through there. Third response. Obviously, a purpose of democracy is to represent, but another similarly important purpose is to serve the people. Therefore, we still serve the function of democracy by being utilitarian good, which is a different function of democracy we're serving. Fourth response. Other principles are also in this debate. For example, the right for cases to be heard in a timely fashion, or for example, for victims to get justice, because evidence deteriorates over time when witnesses forget their stuff, when cases and files are misplaced over time. That should pretty comprehensively mitigate this principle out of the debate. It is gone. Let's talk about cost and time. I think on a question of weighing, this is the most important thing in the debate. You should care more about the speed of justice over small changes in the quality or justice of decisions. There are 3 reasons for this. Firstly, oftentimes our benefit leads to their benefit, because if costs balloon because you need to pay solicitors far more hours and paralegals far more hours, that means people don't go to courts in the first place, which is terrible because you get no decision in the first instance. Second response, justice deteriorates over time because over time witnesses forget their statements. They forget what happened in that instances. All files relevant to the case are misplaced as, firms or businesses move to different locations, meaning you lose that stuff. Third response, I would say there is a principled harm here. It is unjust because it is discriminatory. It discriminates people on the basis of class and on the basis of their wealth. Fourthly, I think that when people get frustrated with courts, they resort to alternative unjust means of resolving case. For example, vigilante justice. Jack Glass gives one means of counterweight, which is to explain, we are happy to spend money when we want to get decisions correct. But we would explain that decisions are made incorrectly under their world when justice deteriorates over time, for the reason I explained in my speech. We explain under this matter, the first thing we explain is appeals are far more likely to happen because of procedural irregularities. For example, the lay judges excessively giving search warrants and stuff like that. We explain this material pretty comprehensively at Will, which is that currently jurors aren't involved in the process, in the investigation process. They just listen to the evidence that is brought before the court. Now, when they are lay judges, when a police wants to execute a power like a search warrant or an arrest warrant, they need to get the warrant of a court, which is given by a judge. Now that they're a judge instead of a jury, the infosite says they're in charge of investigating the cases, and they are also given the power to issue warrants because they are a judge, which explains why they would overextend their power, as we explained at first speaker, which leads to procedural irregularities that are the grounds of appeal, and appeals balloon the cost of court cases. Jack Glass gives 2 responses to this material. First, we misunderstand the role of the police involved in these cases. But police are the ones that do that execute the warrants. It's still like these people, because they're involved in the investigation process, still talk to police. They're inquisitorial, they get their stuff, but they can also issue warrants now. That's really bad, and the info side says that they investigate these cases, and as a judge, they have the power to issue warrants. Second response, Jack explains that the incentive for them to do this is not explained, but we explained at Tom that the reason why they have an incentive to do this is because these people aren't judges. They picked as civilians, they have their own lives to go back to, therefore they want to resolve these cases in a timely fashion and are willing to overextend judges, which is terrible. It involves stuff like giving subpoenas for people that were victims of assault, talking to their counselors, disclosing that sort of information. That is not only an incursion of privacy, a principled repercussion, but it's also bad in other respects. They have other responses to our material about appeals and Glass, which is, firstly, these judgments are written well, but it doesn't respond to the core heart of this claim about appeals, which is that procedural irregularities because of judges overextending their powers or abusing their powers means that you have grounds for appeals. Then they also explain that appeals are often about questions of law. No, they are often about questions of fact. Huge mishandlings of fact can obviously be the grounds for evidence to be struck out on different bases. That is our main reason that flies through the round. Appeals balloon the cost. That's foreclosed. That means that precludes people from going to court in the first instance. They cannot go to court. Their costs balloon. That is absolutely terrible. Besides that, we have two other main claims. First, he explains professional judges are very expensive. You have 3 dudes instead of 5 dudes, instead of 1 dude, right? In some instances. And second of all, we can explain that we can use the money that they use for their case and use it to do stuff like case resolution and whatnot, and so on. Glass says, well, in some instances in our world, you have 3 people or 5 people, but in some instances, like maybe in some chancery courts, you have 1 judge that overlooks a case. Now, that's civils. Okay, so maybe in some instances you have 1 judge that overlooks a case, but now in every instance where there would otherwise be 1 guy, there are 3 people, and that's particularly bad. We overwhelmingly win on the issue of cost and time, and as I've explained on the question of weighing, that is by far the most important thing in the debate. Let's talk about their material on the quality of decisions. Archie's main claim is that judges are worse decision makers. Across his speech, he gives 4 mechanisms. Mechanism 1, more lay judges are more representative than formally appointed judges. 4 responses. Firstly, we explained that we were countermodel. They use huge amounts of money in their work, and we can do stuff like DEI quotas for sexual assault cases, which means that even you can get these people on these cases. Second of all, lay judges aren't that representative, because oftentimes people can't do it because they're time bound, which means that oftentimes richer people are listening to cases, or there are men that are able to make time to listen to these cases, but women are not able to. Third response, mitigation. Civil law jurisdictions have huge bodies of codes that extensively traverse out. They give law reform commissions heaps and heaps of money to stretch out all the possibilities in the law, and there's very limited room for judicial activism. Fourth response, judges do have incentives to make good decisions. They care about their reputation. That's why they went into this career in the first place. Instead of being a partner at Kingwood Malleysons or Allen's Linklaters or any other big 6 firms. And additionally, if it's appealed, it can be seen as embarrassing. Second, mechanism 2, judges are far more prone to corruption and judicial capture. 3 responses. Firstly, I think that this is unlikely for 2 reasons. Firstly, judges are paid a lot. Therefore, they have a lot of independent wealth that offsets the need for corruption. Second of all, they selected this line of work, which explains that they care about their career, care about their profession. Second response, it's far more likely with the lay judges because on average, they aren't paid as much. Therefore, they're far more in need of external sources of wealth because they don't have an independent source of wealth. Third response, mitigation. This is so unlikely. There are grave concerns of you getting arrested if that happens. Mechanism 4, mechanisms 4, seeing cases can bias them in bad ways, but lay judges are biased by the news. And I would explain that the bias by exposure to media and news about crimes is worse than hearing the claims and hearing about both sides' case, because the news has incentives to sensationalize things. Explain why the lay judge's exposure to crime is way worse quality than that of a formal judicial office. Their final claim is, lay judges make good decisions because they can get the wisdom of judges. 2 responses. Firstly, this is symmetric. Jurors can also get the wisdom of judges when evaluating questions of fact. Second of all, this concedes that professional judges are smart and you should listen to them more when you possibly can. Proud to negate.
First, I'm going to to start by weighing our benefit on time, money, and resources. Then we'll deal with how they don't really end up proving theirs. First, on weighing time, money, and resources. There are 4 reasons that this is more important than the claims that they give you. The first one is the worst judges getting worse and worse because you have to divide their salary at least 3 ways because you're paying for 3 of them as opposed to 1 of them. It means that you just get worse quality judges. That means they inform the people worse on their side, that they agree to worse decisions on their side. And because you can't pay them as much, that hits every claim they give you, because that's what their claims are like, oh yeah, I guess people can be informed by the judges, which is the point that those judges become bad. That means the information that the people get to is also legally bad, and that destroys a lot of the benefit this team gets you. They try to deal in a world where there's lots of surplus of judges. Maybe lots of this doesn't change in places like Australia, but I would suggest that in countries that don't have as much money, this is just much worse. And it goes to places in Pacific Islands, this is like a get worse, where they have a low amount of judges. When you go to other places in South America, who commonly have civil systems and don't have much money, it does just get much worse. This team only deals in the developed world without really proving much difference there. But secondly, I would say that our claim just harms more people than delaying than their claim getting the incorrect call. Because the incorrect call maybe harms the 1 person you send to prison, or maybe some vague retribution harm of the person that harmed me did not get punished they talk about. But I'd say that while you're waiting in prison for your case to be heard for 3 years because it's delayed, because it takes longer and longer, that harms you a lot. For the reasons that Jack explains, it's bad to be in prison. They keep people in there for longer who aren't even guilty. That is a problem that they go with. But I'd say it's worse for a person to have to relive their story a long time afterwards and retelling it a long time later to 9 different people instead of just 1. That harms everyone competitively. Third thing I'd say is that our benefit is just much more certain. I will ask a few questions, and if you're able to answer them comprehensively, maybe they have a benefit, but otherwise ours is more certain. What is a correct decision? Because lots of things they say are, this is a subjective case, it's unclear what's happening within it. That implies there is no actual correct decision if it is super subjective, as this team concedes. But I would just note that their benefit is super hard to quantify how much more decisions become correct, and how many of those decisions are incorrect but will become correct in their world. Really hard to quantify. Our benefit is really easy to quantify and explain. It is just that it goes as 3 times as long, you have to pay people far more, you have to cut budgets on other people, I mean the average one comes worse. That is much easier to quantify and explain than theirs. But fourthly, I would note you should weigh ours, because our benefit does not withstand all the mitigation that they do to their own benefits when trying to defeat this one. Because at MIA they explain that there are limits on case times, and ends up mitigating their own benefit because they explain to you that, as we explained second, that means it's likely to be worse because you cut down the case time. But secondly, at Jack they explain, well, police are still going to interview you and still ask you the questions, which means if you believe that the police are white and racist, they're still doing the interviewing of the women who do the sexual assault. That is still a problematic thing. Then they also say at Jack, if the judge thought you were really crazy, then we'd kick you off the panel. But if the judge was racist and thought you were really crazy for having some other opinions, they would also kick you off the panel. That also mitigates their own benefit. But I would note that the biggest piece of mitigation to this team's benefit is just baked into the motion, where it says that you need at least 1 judge to consent to the way that you're doing this decision. And if they explain that judges are overwhelmingly so ingrained and so baked into the ways that they think that they don't want to change, that explains that none of those 3 judges will change. Maybe they will in some specific cases, but not often enough for this to be a large enough benefit for them. It's mitigated down. Let's next go through on their benefits and how they don't prove them. I think the biggest problem is they don't prove that they change case outcomes. Because, as the concession at Third Affirmative correctly notes, maybe it's easy to tell whether you think they did it or not. That's devoid from the legal question if you can prove it beyond reasonable doubt. Maybe it's easy to tell, yes, I think the guy did it, you can't prove beyond reasonable doubt. And I think this team shoots for too low a burden of, oh yes, we'll be able to know if the guy did it better, but don't shoot for the burden of, we'll be able to prove it in court and it'll be beyond reasonable doubt. That means there is a tipping point for all their benefits to accrue that they don't explain. But I think they also never prove that people specifically care about their principle, because they end up making it super narrowly by the end of the debate. It's the specific claim of specific people in specific cases are guilty or not in a very minority of cases that not many people know about, and say they don't particularly care. I think it's more about small confirmed cases, but we explain and flip this that legitimizes bad decisions. They never deal with that. These reasons negate. Easier?
team's case is to believe that we should, for example, entirely get rid of juries. The average person makes a bunch of mistakes, we should just speed everything up. And it's a reason to support, for example, countries like Bukele's El Salvador, where they don't even really ask questions, they just get on with getting things quickly done while the evidence is clean and fresh, and just chucking people in prison because it's for what's good for society. The problem is, what's good for society and who deserves to be punished is a subjective question. It's a question that is hard to answer. And answering subjective questions wrongly, faster and faster, does not a benefit make. Firstly, I'll talk about coming quickly. Second, I'll talk about coming well. Firstly, on coming quickly, they have really two broad claims here that don't actually get proven. The first underlying premise of their entire case is that this would be slow because a lot of these people will argue with one another. And that is kind of the proof of basically all of the claims they spin out in terms of how quickly this will be done, why it takes such a long period of time. But they don't actually spend any time proving it or characterizing it or giving me any mechanisms with which to weigh against. Why is it likely, for example, that if you only need a majority of 5, that you can't get 1 or 2 people disagree? Entirely unproven why a judge would in fact disagree with you. But secondly, if judges are so annoyed as they suggest that they will just give arrest warrants out really fucking nearly to go in just to get the fuck off this panel, surely in those contexts it is also equivalently likely they just flip their judgment, which seems far easier and deals with all of the claims they make far more. Why is it likely, for example, that judges don't listen or can't contribute when their entire case is that these judges are smart and, importantly, are unbiased and are willing to listen to both sides equally? At the very least, they would have had to have provided actual proof as to the thing that forms the sort of load-bearing structure of their entire case to hold up. Because note just how many of their claims spin on from this. Appeals are rushed because the whole process is rushed, because all of these people disagree. The second claim they give is just that we would have to hire more judges. The problem here is that in a lot of cases this is the status quo. Countries don't have to hire anyone else. But secondly, as we explained, this is at a country's discretion, so it would turbo fuck your justice system. Obviously they wouldn't do it. The last claim they make is that we would just use the money for other things. I've explained why that doesn't occur. Then we have a variety of other ways, regardless of dealing with the specific mechanisms that deal with this claim. Firstly, at MIA, we flip this claim, and we just explain that when you split up the inquisitorial duty, it is far more likely you have more time to go through the evidence. Secondly, we establish at first that we would use this in cases where the margin of difference in the result is much larger than the margin of difference in terms of time. Things like sexual assault and murder. And in these contexts, when there is a difference between ruining someone's life forever by finding them guilty of sexual assault or not, we think the distinction in that case is far more important, and we're far more willing to take our time on that. Lastly, or thirdly, we explain there is an upper limit of time. So maybe you use 3 times as many judges, but that is fine. And that we would do it in specific instances in which it is worth it. Secondly, let's turn towards the question of coming well. I think that the problem is a lot of their case is predicated on judges determining whether or not someone is guilty, when in a lot of cases they're determining how to punish someone, right? Like that is the decision that a lot of judges are making. And that's where all of our principal claims are certainly good and don't have to be traded off with time, because it is people deciding whether or not, for example, someone who should be sentenced to die for a crime, or whether or not that should be a more lenient sentence. And all of that doesn't incur all of the claims that they make about whether or not you would investigate something or some such. It just requires a bunch of subjective decisions people should and can make about their moral biases. And here is where Will's weighing about whether or not we know that something is a good decision works against them. We don't. And the only way in which we can arbitrate that is by getting more demographics, getting more people in the room with which to make that decision. We provide a variety of other harms on this question towards judges just being worse, towards there just not being as many people means you're not likely to make the right decision, towards not having the correct demographics, towards having a thing that skews towards people who more likely seen poorer people stuffed in jail and are less likely to be accountable. At the end of this debate, they don't actually prove the thing that they need to, and they spend a lot more time coming quickly than they do coming well.